Hello, thank you for signing up for this webinar. We hope that it's better than the last one, that's for sure. Those of you who attended the last one, thank you for your suggestions. Many of them were that we should discontinue this talk whatsoever. Those we threw in the white garbage, and the other two suggestions we did follow. Yes, we will try to stop on time for a change, but the Gassman guy just keeps talking and talking and talking. Could you not get more sick of that? I don't know. Anyway, as always, we're going to provide you with lots of information, some of it actually relevant, humor, not so much, and complexity that will make your head spin. By the way, on the PowerPoint, Ketron is not that much taller than Gassman. It just looks that way because of the angle of the shot, and we'll try to correct that next time. Anyway, thank you for signing up, and they welcome your questions. Okay, welcome to our 5th or 6th Saturday webinar. We very much appreciate all the participation and all of the enthusiasm that Brandon has for this program. So please send us your questions. We love answering questions, and we'll answer them during the program. Today's talk is trust structures and strategies, and we want to talk about how these structures come together and how we strategize. One of the things I'd like to do to begin with is just to bring a Excel document onto the screen here. And this is a sterilized version of an estate plan that we had in progress last year. And one of the things that we make sure that we do to the best of our ability is show all of a client's assets and entities where they exist. So we're always going to have the client's names at the top, the entities that they own or control below them, and then the assets of each entity below that. And it is a strenuous process to get a list of all the assets. And then during this process, we're also sketching out with the dotted line circles where things can go. It's almost like a construction project. So the home could go under 2 different qualified personal residence trusts. We'd like to restate and amend the trust agreement. We know here about some assets, but we hadn't received information on the ownership of them yet. But this is how we can track this, and it's all an Excel document. If anyone would like, we can email it to you. Just put in the RE line of an email, send me the sample Excel document, and then your staff can learn to draw these circles and squares and all these things we were going to do for this client. Put a lot of assets into an LLC, and then we were going to set up a spousal beneficiary trust, as you see there, and a descendants trust, and an irrevocable gifting trust, and then we were going to have part ownership of the LLC by those trusts in exchange for promissory notes. But my big message here is that in order to have a successful estate plan, you have to know what the client's assets are, and you have to show the client where they are and where you want them to be. And then when the client calls me on the phone, I can pull this chart up and pretend that I know all about her and remember all these things, or she'll know I have the chart up. But it's a great communication tool. And we have architectural printers in 48-inch rolling paper, because some of these charts are running 10 to 12 feet long, about the size of an alligator. Now, as we always say, we did not qualify this Saturday series for continuing education credit. It's a lot of work to do that, and we really wanted viewers who wanted to be here to get the knowledge, not the credit. So as I always say, not only is there no credit, but if you tell your accrediting organization that you've attended this webinar, you may lose other credits. So be careful. You will get a recording of this webinar 1 hour after we're finished, whether you want it or not. You can then click on where it is, and you'll be able to see this on YouTube. You can also forward that to your friends or your enemies or a little bit of both. In addition, if you click on the questions panel there that you see the purple arrow on, you can go ahead and type in a question. And we've already got quite a few questions. Thank you, Cynthia, Claire, David, Rob, and Fred for your questions. And I've already answered a lot of these questions. Rob's a little bit confused, though. He says the sessions are very valuable. Well, I hope they are. We do have a YouTube channel. You can just go to YouTube, Gassman, Estate Tax, and there you'll see all of Brandon's masterpieces. We're very proud of our charitable series and shameless self-promotion. So we actually planned ahead. Next Saturday, we're going to do a special update on recent developments and hot topics. Then the following Saturday, mathematics. The next Saturday, hard questions and interesting answers. And then the following Saturday, estate planning for business owners. You can sign up for all of these or one at a time, whatever you like. In addition, on Wednesday the 21st, I'm going to be talking with Professor Jerry Hesch and Michael Lehman on charitable planning for business owners for St. Petersburg College. You're welcome to join us. So the logistics of an estate tax plan or of any tax plan will typically involve, for a single person, the ownership of a homestead if they live in Florida, which is creditor proof, the ownership of a revocable living trust to avoid probate and guardianship, which gives you no creditor protection. It may hurt your creditor protection, and it gives you no estate tax protection. Ownership of assets in part or in whole by an irrevocable trust. We often call them gifting trusts. That's not a technical term. It's just a warm and fuzzy term. Sometimes offshore trusts, sometimes Nevada trusts for reasons we'll describe, and then assets typically in limited partnerships and limited liability companies, just so you're aware of that. For a married couple, typically for most clients outside of community property states, and because of the way this is done traditionally, each spouse has a revocable trust. And the revocable trust says, if I die, for my sad widow or widower, take the first $11,700,000 or whatever my exemption is, put it into a family trust, also known as a bypass trust, also known as a generation skipping trust, for my dear surviving spouse. My spouse could be the trustee, receive amounts as he or she needs for health, education, and maintenance, and have the right to direct where it goes when my spouse passes away. If not otherwise directed, then this can go into lifetime irrevocable trusts for my children to benefit my children. My children might become trustees or co-trustees with the right to receive amounts as reasonably needed for health, education, and maintenance. And then it will benefit them for their lifetime. And when my child dies, it can go into continuing trusts for the grandchildren. And how long can it go? Well, Florida, 360 years. Nevada, 365 years, which is a good reason to go to Nevada for those extra 5 years. South Dakota, 999 years. I was reading today one of the oldest trusts I've ever read, a 1948 trust. And in 1948, a trust could only go 21 years past a life in being. And this trust was for a gentleman's children, and those children have now died, and we're waiting until the 21st year after they died to release the trust assets. And let me tell you, that is one great-grandfather who is being remembered as everyone looks at this 1948 trust and anticipates the distribution of assets that they would like to own and that they will own. If the first spouse leaves more than the exemption amount, the excess can go into a Q-tip marital deduction trust, no estate tax on the first death, protects the assets from next spouses and creditors of the surviving spouse, has to pay the surviving spouse all income on the surviving spouse's death, can continue for the lifetime of the children, but will be considered as owned by them for federal estate tax purposes. Then you have an irrevocable life insurance trust. Life insurance is subject to federal estate tax. It's income tax free if properly situated, but if I die and leave that life insurance to my spouse, then it will be subject to estate tax. And when she dies, it'll be part of her estate. I may die and leave it to my trust, but then it's going to take up part of that $11,700,000 exemption amount. So I can place it in an irrevocable life insurance trust. My spouse or my best friend can be the trustee. When I die, if it's been in the trust at least 3 years before I die, or the trust bought a new policy, then it doesn't count against the $11,700,000 exemption. And it can be held for the health, education, and maintenance of the spouse and then the children. It can also be generation skipping. So a lot more life insurance trusts will be formed and maintained after the exemption goes down in 2026, if it goes down in 2026, or if it doesn't go down before then. What happens to the surviving spouse? Well, they have a big party when the first spouse dies. They get remarried. They live happily ever after and leave everything to the next spouse's children, unless you're careful. So this Q-tip trust protects your children from the next spouse's children. But what the surviving spouse has is not protected. And that's a disadvantage of having two separate revocable trusts. If you have two separate revocable trusts, you could sign a marital asset protection agreement, which says that the surviving spouse is required to deposit a large percentage of the assets that he or she would own into an irrevocable trust that benefits the surviving spouse and your descendants, but not the next spouse. Brandon, anything you'd like to add to that?
No, I think it's good explanation there of basically the basic estate plan that is set up for majority of our clients, at least from a starting standpoint. And then there's additional layers that are tacked onto this, but this is a good job of the basics.
Okay, so we want you to think about what goes under each trust, because the biggest mistake over and over, clients sign the most beautifully drafted documents, and then they go home and they don't do the retitling. So make sure that you have a chart that shows the client where everything should be titled. Now, for most of our estate plans, we don't want any assets in the revocable trusts until a client dies. We leave most of the assets jointly as tenancy by the entireties because so many of our clients are doctors, lawyers, CPAs, and business owners, or they drive at night in the rain in Pinellas County, Florida, and they may get sued. So you've got to balance your creditor protection against your asset protection and do the right things. We show an irrevocable trust here that the spouse 1 and spouse 2 can transfer assets to for the children, up to $30,000 a year per child if you like the child, less if you don't like the child. And then the spousal limited access trust. Spouse 1 can make a gift to the lifetime bypass trust, also known as a spousal limited access trust. Spouse 2 can be the trustee, can receive what spouse 2 needs for health, education, and maintenance. In fact, an independent trustee could have the power to give the spouse the whole trust. This trust is out of the estate tax system. It uses up part of spouse 1's $11,700,000 exemption. And then if spouse 2 divorces spouse 1, what happens can depend upon how the trust is drafted. If spouse 1 has $11 million from a prior premarital assets that are protected in the event of divorce and puts those assets into the lifetime bypass trust, then the bypass trust may say that in the event of a divorce, spouse 2 is out and it's only for descendants and spouse 1's next spouse. So then spouse 1 can remarry and indirectly benefit because the trust can benefit spouse one's new spouse. And then when spouse one dies, the new spouse is out and it's just for the children. That's called the floating spouse. It has nothing to do with the ability to swim or how the spouse looks in a swimsuit. It just means the spouse is replaced on death or divorce. On the other hand, if this trust is funded with assets of the marriage, then spouse two would not want a floating spouse provision. And on divorce, this trust may divide into half. One continues as a spousal bypass trust. One may be controlled by spouse one controlling the trusteeship. And if this trust is formed in an asset protection trust jurisdiction, such as Nevada, South Dakota, or Nevis, then spouse one may be added as a beneficiary after the divorce if there are financial needs to do so. And of course, we can put in subsidiary entities so that we don't have assets directly owned by these trusts. Spouse one, believe it or not, may want to manage the assets that he gifts. So it goes to a LLC managed by spouse one carefully. The LLC is owned by the bypass trust. Spouse two owns the LLC as trustee, but spouse one calls the investment decision shots. Now, if you're in a community property state, especially California, then you woke up really early this morning. You woke up at 8 a.m. Pacific time, and I commend you on that. But in these community property states, the tradition is to have a joint trust, and the joint trust becomes irrevocable on the first death as to the first spouse's half of the community property trust. And unlike the other states, when I die a Floridian with joint assets with my wife, then my half of the assets get a new income tax basis equal to fair market value. But my wife's half don't get a new income tax basis. But for some reason, individuals who live in these community property states, which use basically Spanish European law, get a step up of all assets. And that's the advantage of community property and the community property trust. But there's a distinct disadvantage. In most of these states, including California, if spouse one gets sued, they can reach all the community property, including assets belonging to spouse two that came about during the marriage. So for our handful of clients who happen to be in community property states, we will have them transmute out of community property status. And if they want to continue a joint trust, we have them form what's called a joint exempt step-up trust, which we developed years ago. And on the first death, you get a full step-up, plus, instead of having only half of the assets or the first dying spouse's share of the assets lock up on the first death into a credit shelter trust, with the JESTS trust, all of them can become irrevocable on the first death. So if the couple only has 800,000 worth of 800 million worth of assets in their joint community property trust, one dies, you've only locked up 4 million. You've left a lot of the 11,700,000 not used. But with the JESTS trust, you could have the whole 8 million go into the credit shelter trust system of the JESTS trust. And then the second thing we did for these particular clients, with the help of California Council, was to form a trust for their lovely grandchildren, owning 1/2 voting interest in their Nevada LLC, so that on the death, we wouldn't have the full value of the underlying assets. We'll get a significant discount because the couple only owns half of the voting rights. So if this is $100 million in assets, instead of being worth $100 million on death, it's going to be worth somewhere between probably $60 to $70 million. And then what we might do is transfer half of the ownership of the Nevada LLC to a trust for descendants or to a trust for the spouse. If you transfer more than half in California, you can trigger reassessment of the real estate, which is not a pretty sight. So you have to be careful with that. So these logistics and these structures are very, very important. It's important to show clients how they work, and it's important to draw it out and think it out and run the numbers carefully. So we have more slides that the advisors on this program can use, which talk about the JESTS trust. If you Google JEST Trust Gassman, I think our articles will come up. There was one in the Estate Planning magazine, and there a two-part in Estate Planning magazine, I think in 2013, and then a one-part on the Lineberg system. And a lot of people have been using the JESTS trust to get the step up on the first death. And here we have just some categories of comparison of the JESTS trust to separate revocable trusts, to what we call a joint tenancy by the entireties trust. And we're now updating our literature because Florida has passed a community property trust statute, or it will be law July 1st, unless the governor vetoes it, and I don't think he's inclined to veto it. So then people from all over the country will be able to set up a Florida community property trust with a Florida trustee, put assets into the trust, and claim a step up in basis on the first death. I use the word claim because the law is not absolutely clear on whether you get that full step up. And we published an article in our Thursday report yesterday, or actually on Thursday, and it will be coming out again, I believe, today, part 1. If you want that community property trust article and you don't have it, then just let us know, put it in an RE line. So Brandon, should we mention the Clayton Q-tip trust, just because it's important to have in documents?
Yeah, so the Clayton Q-tip election essentially allows you to make a Q-tip election after the death of the first dying spouse, as long as the trust is appropriately drafted and allows the trust, I guess, to be Q-typical in a way. So the trust would have to provide that all income is paid to the surviving spouse at least annually. The spouse would have the right to make the assets productive. So if you include those provisions in there, then you can make what is known as a Clayton Q-tip election. I believe it's 9 months following the date of death of the first dying spouse. That would allow the assets to go into a Q-tip trust. And one of the benefits there is then it would be included in the surviving spouse's estate and would definitely get a step up in income tax basis. Whereas if it was held in the family trust, it may or may not get an income tax basis depending on the way the trust is drafted or certain powers that you might include in that trust to allow for that to happen. But you can use the Clayton election if estate tax is no longer a concern, and to pass assets to a Q-tip trust to get a step up in basis.
Okay, very good. So again, more slides which talk about the JESTS trust for those of you who want the access to these. You're welcome to use it. Now, I want to mention what we call the irrevocable JESTS. And this is where the clients would like to set up an irrevocable trust to make sure that their children are well protected. So you have an elderly client or an infirm client, and she has more assets than she needs, and her children want to make sure that their inheritance is squared away and that nobody takes their inheritance away. So maybe half of the assets, excess assets, go into an irrevocable trust for the son, half go into an irrevocable trust for the daughter, so you don't have to worry about a parent with dementia giving the assets away, but you can still get that double step up. When the first spouse dies, you get a step up, and then when the second spouse dies, you get a step up. Or, for example, I could form an irrevocable trust for my wife and children, get it out of my estate for estate tax purposes, and give my father-in-law the power to direct the trust assets to creditors of his estate by what we call a limited power of appointment. My father-in-law can also be a discretionary beneficiary of the trust. and his ability to direct the assets to creditors of his estate could be limited by needing the consent of a couple of my friends who are not beneficiaries of the trust. Now, when my father-in-law dies, the assets of the trust get a new income tax basis. Ed Morrow, M-O-R-R-O-W, has written a lot of articles on this. He's really been a pioneer on all the technicalities. He calls it the OBIT trust, O-B-I-T. I don't think it has anything to do with obituary. I forget what it stands for, though. And it's worth checking out his articles because he's so brilliant and he writes so beautifully. Now, this spousal limited access trust, also known as a dynasty trust, should be carefully thought out. We have an article in the material somewhere called Slatopedia that we published with Bloomberg a few weeks ago. If you don't find the article or you need a copy, it's Slatopedia, like life insurance, like a encyclopedia, which is what we had before we had cell phones when we wanted to look something up. It's a pretty good article. It has pretty much everything we know and remember about them, and you have some slides here that you can use. Brandon, do you want to take us through slides 51 and 52 as far as how we're using discounts and irrevocable trusts for married couples?
Yeah, so this is another common plan here that we do for clients that are estate taxable. Use of the SLAT and the Descendants Trust that Alan mentioned to sell assets to the trust in exchange for a note. So what we first do is either contribute assets to an LLC or use an existing LLC that the client already has, and we might restate and amend the operating agreement, amend the articles of that LLC to recapitalize the LLC into a voting and non-voting structure. That way we can sell a non-voting interest in the LLC to these trusts that we can set up and take a discount, because when you're purchasing something for, from a third party, if you don't have any rights to control what goes on in that business, you're not going to pay full fair market value for that. You're going to ask for some sort of discount, and you can do the same type thing in estate tax planning. So while the assets under this LLC might be worth $20 million, you might be able to take a 30% discount for lack of control, lack of marketability. So that $20 million would then turn into $14 million. The other part of this is, so then the trust would owe a note back to each of the clients equal to whatever the valuation says that non-voting interest is worth. It's going to pay low interest only each year. So we're essentially freezing the value of the estate at whatever the discounted value of the LLC interest are. And it does a nice benefit from estate tax planning. The second part of this is that these trusts can be disregarded for income tax purposes, and spouse one and spouse two can actually pay the income taxes that the trust would receive each year from the income of the LLC. That's not going to be a further gift to the trust and further decreases the value of their estate. So that works really nice as well. The third layer of this, as you see on the far right, we have this irrevocable trust that holds a, we call it the special voting interest. And that special voting interest says that this special voting interest is the only person that can determine if and when there would be a liquidation or a distribution made from the LLC. There's been a couple of recent cases where the IRS has said if the client retains the right to control when something can come out of that LLC or when it can be liquidated, that's a retained right that could cause estate tax inclusion. Even though they only own 2 or 3% of the entity, it can cause the entire entity to be included in their estate. So we set up a separate trust. We have the trustee be someone that's not related or under the control of the client, and give them the rights to determine when a liquidation or distribution can be made. The trustee can be replaceable by the client, so if they don't do the things that they like them to do, they can find someone that will and still control this in a way, but that gets rid of that right from their estate, and therefore the IRS hopefully would no longer be able to make the argument that the assets of the LLC should be included in their estate because of those retained rights.
Beautiful. Very, very well described. So Internal Revenue Code section 2036A2, that's the Internal Revenue Code section of the day, says that if you give something away, but it's not a bona fide sale, then, or it's not a bona fide transfer for good and valuable consideration, then if the person who gave it away has retained the power to direct if and when it will be enjoyed, it's considered to have not been given away. So the two court cases that say this are Commissioner v. Strangi, Strangi, and Commissioner v. Powell, Powell. And in both of those cases, families did very aggressive partnership planning while the parent was almost on their deathbed, and the parent died very quickly after that. And in both situations, the voting rights were given to a close relative who had a power of appointment, a power of attorney over the parent. So the IRS said, and the tax court said, you're really a deemed agent of the parent when you hold their power of attorney, and you're also holding the voting right to a partnership that they own 99% of. That is too close for comfort. So this is why we appoint a separate individual who is not high up in the hierarchy of appointees under the client's other revocable trust and power of attorney documents to have the sole power to determine if and when there will be a liquidation or distribution. Now, to our knowledge, the IRS is not bringing the 2036A2 issue up in routine audits or reviews. They're only bringing it up in abusive situations. And if and when these tax court opinions are appealed, I think that the IRS will lose on the appeal, because there's a Supreme Court case that had a similar situation for a business corporation where the court said this wouldn't apply for a business corporation. That's the Byrum case, BYRUM. So we have really beefed up our LLC agreement to provide a lot of fiduciary duties. In addition, as I said, 2036A doesn't apply if it's a bona fide sale or a bona fide transaction. So if there are good business reasons to put this LLC in place, and mom and dad put their assets in and the trustees put pro rata assets in, and this is to settle a family dispute, or this is to save mom and dad's assets because they're getting minor dementia, they're getting confused. This is to save a neurosurgeon's assets because he may be sued, or a developer's assets because they may be sued. If you have bona fide reasons and you put together the transaction carefully, 2036A2 should not apply. Now, or hopefully would not apply anyway. I want to go over some questions and answers before we forget to do them. Fred says, will there be a recording? My audio is choppy. Yes, and hopefully your audio will not be choppy. But if you have a blender on, turn off the blender. And, if you drink Bloody Marys, you won't need a blender. But if you're drinking the margaritas in the morning, that will cause the audio to be choppy. Second, please send me the Excel spreadsheet. I will do that, Cynthia. Thanks for asking for it. Claire, is there any chance of condensing the handouts? 196 pages is so much to print out. I do apologize. It's like that letter that Mark Twain wrote. I don't remember the exact words, but it's like, I apologize for the length of this letter. If I had more time, it would have been shorter. It's so hard to figure out what slides not to show. David, you should check out software like MindManage, which may be used to collapse or open various pieces of spreadsheet, visually appealing to clients. I will look at that, David. But we have 28 users in our office, and if it costs $500 per user, it's expensive, and then clients can't manipulate it on their side unless they buy it. And I'm an old guy, and I don't like to change. Okay. Next, Nancy, how do you remind the client nicely to keep titling assets properly? I have one that constantly forgets where he should be owning assets. Nancy, if you have only one client that forgets where he should be owning assets, then you probably only have 2 clients. All clients do it. How do you nicely remind them? I guess over and over and over again, and you can't be all that nice. You just got to remind them. But it's a good idea after a couple of years to just mail them a copy of their chart and say, here's the chart. Is it right? Is it wrong? And have you retitled your assets? Because it is a very big thing. I am impressed with, let me see here. Somebody told me what OBIT stands for. But I forgot. Okay, David. Alan, you did not discuss 678 trust strategies. Are they viable? Yes, we do use 678 trusts. Brandon, do you want to explain what a 678 trust is and how we would use one?
Yeah, so the 678 trust is pretty unique. It's similar, it's a type of grantor trust, and a grantor trust is where the grantor of the trust, meaning the person who funds the trust, pays the income taxes on the trust. Now, 678 trust is similar in that manner in that the beneficiary actually pays the income taxes on the trust. And that applies, and it's a disregarded trust, so you don't have to distribute assets out of the trust to pass the income tax burden out to the beneficiaries. It can stay in the trust and the beneficiaries can still pay the tax. So how do you set that up? Well, you give the beneficiary a right to withdraw the income of the trust or withdraw all of the trust. And then if they have that power coupled with one of the other grantor trust powers, that causes the income to be taxed to the actual beneficiary. That can be really advantageous. Section 199A planning is one area where we've used this in the past, where we've set up a 678 trust, gave part ownership of a business that would not otherwise be eligible for the 199A deduction because the client's income is too high. So you give maybe 10% of the entity to the 678 trust for the beneficiary. The client can control when that beneficiary gets distributions, but the beneficiary pays the income tax on that and gets the 199A deduction. Another recent strategy that we're looking at for one of our other clients is a 678 trust where an old trust is actually deemed to be the grantor of a new trust and pays the income taxes on that new trust. So how does that work? Well, if the old trust is a non-GST trust and the new trust is GST exempt, meaning that you wouldn't have to pay generation skipping taxes on the new trust whenever distributions are made to grandchildren or if it terminates for some reason, you can essentially freeze the value of the non-GST trust and then have that trust pay taxes on the new trust and allow for the non-GST to kind of drip down and decrease in value while the GST part is increasing in value. So that can be another strategy to use 678 trust. And maybe in the next couple of weeks, we can talk a little bit more about those with some illustrations and give some details, because 678 trusts are pretty unique and there's a lot of good strategies involved with them as well.
The 678 trust is really good if you're going to buy a house for a child. You set up an irrevocable trust for your spouse and descendants, and you give your child the right to withdraw what you put into it, and then you use that money to buy the house. Now, for income tax purposes, that trust is considered as owned by the child. So when the house sells for a profit, you get the child's $250,000 exemption for the sale of a primary residence. So it's really good when children go to college or graduate school and the parents buy that first house. It's not really for the child, it's for the family, but you want the child to be considered to be the owner. If you search YouTube Gassman 678, you'll see a little video where I explain the 678 trust to my granddaughter and who's allowed to live in the house for her 20 years from now when she'll be age 21. And people have said it's a cute video. Sharon, thank you very much. You have told me the name of the trust invented by Ed Morrow is the optimal basis increase trust, the OBIT. Thank you very much for that. Okay, here's another one from Abigail. can the trust protector under a trust make a gift to the trust? And the answer is you could make the gift, but then when the trust protector dies, it's going to be included in the estate of the trust protector for estate tax purposes, because that's a retained control under section 2036A. In addition, if I set up a trust that's disregarded for income tax purposes because I have the right to replace trust assets with assets of equal value, and then Brandon puts assets into the trust, then the trust is not all disregarded anymore. Now it's a garbled trust, named after Greta Garble, who did that with Humphrey Go-Kart. All right. Here, for your convenience, are the updated applicable federal rates. If you have an extra $1 million lying around that's earning interest at 1% in a short-term bond fund, why not loan that $1 million to your grandchild's 678 trust, and they'll pay you 0.13% a year, and they'll earn that between 1 and 2% on average in that short-term bond fund, and they'll pay the tax at their lower bracket. And then when you want the money back, you just get it back. So, that's kind of a no-brainer. Or if you want to lock the interest rate in for up to 9 years at only 1.02%, you could do a 9-year note, repayable without penalty. Or if you want a long-term note, like a 30-year note, then you go at 2.8%. Now, if it's an installment sale, you don't have to use the month of the transaction. You can use the month before or the month before that, so you can go with an April 1.98%. With inflation rearing its ugly head, it would not surprise us if the rates don't come up. Look how they've come up from October 2020, 1.12%, to June 2021, 2.08%. I don't know that that's really significant in the scheme of things when you use these notes for long-term planning. 2.1% is almost as good as 1.212%, but it does show you the way things are going. And you can do installment sales. You could use a higher interest rate and do what's called a self-canceling installment note, where on death, the note cancels. For example, for this 73-year-old in April, he could have done a 1.98% long-term note or a 6.2% 12-year balloon self-canceling installment note. And then if he died within the 12 years, hip, hip, hooray, the debt is done. When clients call, we tell clients, after we tell them to put all their assets in the right place and to call us every 3 years the rest of their life, we tell them, if you're in bad health, call us. It might be a great opportunity. When you get that bad health information, call your spouse first and us second, so that we can put this into place while hopefully there's time. A private annuity sale works the same way. And then there's the grantor retained annuity trust. And here's where you would show that you could do a joint self-canceling installment note or a joint private annuity. So the numbers there, so you can see them. This married couple in their early 60s, they could do a self-canceling installment note for 3.2%, a 21-year note. And if they both die within the first 21 years, the note completely cancels. So that is something worth doing. Oops, let me see if I can get my PowerPoint working again. It was going so well.
Probably have to zoom back out, Alan, and then
There we go.
if you're zoomed out, you should change. Yep, there you go.
I hit escape. Let me now show you another true story. And this is an Excel document that I'll be sharing. And this is the story of Jane Smith. That's not her real name. Her real name is slightly more exciting than that. And she has a revocable trust that you can see there. And she formed a irrevocable trust for her children and their descendants. We called it a dynasty trust. And then she formed, and at the same time, she formed a Wyoming LLC. And she had several investment properties, and we felt they should all be in separate LLCs. So we put them in separate LLCs, and then we put her ownership of the LLCs under a holding LLC. That kind of gives her double insulation from liability. And then we set up a voting trust to avoid 2036A issues. She put money into that trust, and then she put the real estate LLCs into Wyoming 2 LLC. The trust contributed cash pro rata to ownership. She kept part of the voting rights. Her daughter is the manager of the LLC, and another person is the manager of the real estate LLCs. And then she sold a part ownership in the LLC to the Dynasty Trust in exchange for a promissory note. And we had to, of course, get valuations on these properties. Ideally, MAI appraisals, but in the real world, broker opinions of value. And then with her other assets that she did not want to put into this mix, we set up a separate Wyoming LLC, and we have it owned 0.5% voting by the Dynasty Trust, 0.5% voting by her, and then majority ownership by her. So it's still mostly in her estate, but if she dies, we're going to claim a discount. And if somebody sues her under Wyoming law, they will only be able to get a charging order. They won't be able to take over her 97% of the asset. Wyoming has good charging order protection, and Wyoming does not disclose the manager of an LLC. So when people find that these LLCs own property and they go to the Wyoming website for the Wyoming Secretary of State, they're not going to find out who the owner or who the manager of that LLC is. We use 007 registered agent services. So all they're going to see is that 007 is the registered agent. And Kurt, who runs 007, has promised us he will not disclose the information about any of our clients to anyone who ever calls him. And we think it's neat that the name of his company is 007. Now, and Wyoming also recognizes tenancy by the entireties, by the way, and even if you don't live in a tenancy by the entireties state, there is some support for the proposition that if you and your spouse own a Wyoming LLC as tenants by the entireties, or a Florida LLC for that matter, and someone sues one of you, they may not be able to touch the tenancy by the entirety assets, according to a recent Iowa Supreme Court case. Then she had an old family limited partnership. We dusted it off, we updated it. It already is owned by a separate irrevocable trust in part, but we set up some new control mechanisms under the limited partnership, and we had her sell the rest of her remaining limited partnership interest, or transfer it actually, to the Wyoming LLC. So in essence, we were able to claim a two-tier discount because she only had a minority interest, non-voting, in the limited partnership. So if we were able to take a 30% discount at the partnership level and a 30% discount at the LLC level, that's equivalent to a 51% discount, because 0.7 times 0.7 is 0.49, for those of you who are math fans. So that's a good example. So Brandon, we're way over our time. Is there anything you want to do or say before we sign off, or do you want to go over time with anything in particular?
No, I think that it's just, one thing to point out here is, while we have the basic structure of, the installment sell with an LLC, that there's several layers and wrinkles that still need to be considered as part of that. You always want to consider asset protection. So you don't want to just throw anything and everything under one LLC and sell it. Maybe you have, like we had for that previous chart with Jane Smith, 4 or 5 LLCs as subsidiaries layered underneath it. That way you can insulate the liabilities under each of those LLCs, and if something goes bad with one investment, you're not going to lose the rest of them. So while we have the basic plan, there's wrinkles involved and there's layers to be considered. And you should always mention those with clients or discuss those with your advisors as well.
Absolutely. Okay, let me see. I'm going to answer the remaining questions because the questions are great and I think people really like to hear the questions. Blair, I have a client with a policy that she's paying in an irrevocable trust where the beneficiaries are incorrect. We want to set up a new irrevocable trust to transfer the policies. Tricky. Well, you're right, Blair. What we do most of the time is we value the life insurance policies in the less desirable life insurance trust, and then we sell them to the new trust. So you have $1 million death benefit, $100,000 cash value. The carrier tells you that if the client's of reasonable health, they could replace the policy for $150,000. That's called the interpolated terminal reserve value. You set up new irrevocable trust number 2, put $150,000 in it. It pays irrevocable trust number 1 $150,000. It owns the policy. Irrevocable trust has $150,000 when the client dies, and then that's reasonably invested. When the client dies, the old beneficiaries share $150,000 plus what it grows to. The new beneficiaries get the $1 million. Of course, that's going to backfire if the client lives too long and the policy explodes or doesn't have a great rate of return. But that is one way to do it.
Yeah, and Alan, just to mention on that as well, we have actually a slide on slide 100 that talks about something similar to that, where we had a non-GST trust holding a life insurance policy that we wanted to move into a GST exempt trust. So we did something similar where we sold policy for the interpolated terminal reserve value to transfer over. One thing you do have to watch out for is both of those trusts need to be grantor trusts for income tax purposes to avoid what's the transfer for value rules, and that way you don't trigger taxes on the transfer of the policy. So make sure those are both grantor trust when you do transfer the policy.
Okay, I couldn't find that, but at 132, I've got the 678 Child's Homestead Trust, so maybe that's good. Okay, Jeffrey. Jeffrey worries that a long-term note in excess of 15 years might be recharacterized by the IRS as something other than debt. This concern comes from the old days when we were worried about the 385 regs. Is this just tax paranoia? Jerry Hesh believes that it is safest to go no longer than the client's life expectancy. And there's a pretty good article in a Thomson Reuters installment sale brochure, believe it or not, but it's a really nice article by Mike Mulligan, and he reviews this issue. So our rule of thumb is that we don't go longer than the client's life expectancy on these notes, but there is, if you have an interest rate on the note, you pay the interest. We don't think the IRS has a good position there, but we do agree with you on that. Okay, Claire, the annual Florida fee for LLCs is $62.50. Is it worth that amount every year to protect the real estate? Heck, yes, it's worth a lot more than that. When clients get sued because of real estate ownership, it is not a pretty sight. So the regular renewal fee for a Florida regular corporation is $62.50. For an LLC, it's $130, I believe. I think it's worth it. Thanks for asking. Okay, Michael. Alan, I heard you say in the example that you recommend that each property is owned by a separate LLC, and then the holding company owns the LLCs. Can you explain the protection here? It sounds on the surface that the properties are not protected because they are tied together through the holding company. Mike, that's a good observation, but fortunately, under the laws of almost every state, the courts are very protective of separate companies as long as there was no fraud, mismanagement, or co-management. So if each company owns a separate property and is properly managed, it should be very difficult to break the corporate veil to get to the parent. It's not impossible, but if you like, I've got it, especially for Florida, we have a very long white paper on this because we've studied it many times for a number of clients. We'll be glad to send that to you. We think it's worthwhile to have the separate LLCs for separate properties. Okay. Brandon, here's one question I think we can close with. And that way people who want to get back to their families can do that, but people who don't like their families don't have to. And that is the question is, what may happen in estate tax law changes, and what are you recommending to clients to do about it?
Yeah, so big proposals, I guess, big picture is one, a drastic reduction of the estate tax exemption amount. The proposal right now is to take it down from 11 million per person to 3.5 million, I believe, per person. It might end up somewhere in between. We don't really know where it's going to go, but we do think it might be reduced at some point. The other proposal that's pending, probably a little less likely to pass than the deduction of the exemption amount, is a capital gains tax on death, and also a capital gains tax on transfers to either trust or other individuals that would make the transfer go outside of your estate, and a very small exemption amount for that of only $1 million. The good news is if we get this planning done now, it's all grandfathered. So none of those proposals would impact anything that you would do before the effective date that would pass. So I think the main thing we're recommending to clients is let's get all this stuff set up and ready to go. If we do see that the exemption amount is going to come down, let's go ahead and get it done as quick as we can before that becomes effective. Use as much exemption as possible. Have a GST dynasty trust set up that can go for 360 years in Florida and be grandfathered as a grantor trust, which is also something that they're targeting to try to include grantor trust in the state. So we want to get this stuff done now, set up, ready to roll, and done quickly before anything were to change.
Super. All right. Well, we'll be back next Saturday. We hope you'll join us. Please tell your friends, family, enemies, anyone you know. We're looking for audience. We really enjoy these. Please send us any and all of your suggestions. Appreciate everything. Mary sent us cookies last week. They were excellent. Our staff enjoyed them. Have a fantastic weekend. It's all about family. It's all about friends, and it's all about enjoying what you do. We enjoy this very much, and we hope you do also. So thanks very much. From me, from Brandon, and from me, thank you again, and have a fantastic weekend. Woo!